Hi, this is Heather Orr with Bootleg Legal, and today's bonus lesson is going to be about negotiation and persuasion. This is a bonus lesson because it is not integral to you understanding business law by any stretch of the imagination, but it is interesting and it tends to resonate with a lot of people. So here goes. When I was in undergrad, I took a course called Persuasion. It was a psychology course. And we were told to do a real life experiment using at least two of the persuasion methods that we were taught. So my group decided to use reciprocity and social pressure. And what we did was we set up in the middle of campus with a donation box. And we said, hey, we're raising money for the Boys and Girls Club, which we were. We did give the money to them. And in the first round, the control round, we would just ask for donations and then note how many people gave them and what amounts they gave. Maybe like 1 out of 4 people would give us a couple bucks, right? Nothing too extraordinary, also not too surprising. In the second round, we were testing reciprocity. Now, reciprocity is the idea that if, as humans, we are pre-programmed to give something back if somebody gives something to us. And it doesn't matter at all if the thing that they gave us is something that we value or has value, or even whether it's something that we want. When somebody gives us something, we have a trigger in our brain that makes us feel obligated to give something back to them. So we got to fully test this theory, we got the cheapest thing we could think of, which were those gross, hard pink bubble gums, right? They're like 5 cents a piece. And so this time we would walk up to people, we would hand them a bubble gum, and then afterward, we would say, would you like to donate to the Boys and Girls Club? Our donation rate doubled, it might have even tripled, just because we gave them a 5-cent piece of crappy candy. Everybody was like, okay, here you go, you know. But they were still giving small amounts of money. $1 here, $2 here, maybe a 5 would be the biggest that we would get. So the third round, we tested social pressure. Social pressure is the idea that people respond to what everybody else around them is doing, and they feel sort of obligated to fit in, you know, to conform to whatever societal expectations are around them. So on this one, we had a clipboard. And on the clipboard, we wrote fake donation amounts. Like Bobby Jones gave us $15. Sally Mae gave us $20, right? So we filled out this clipboard. And this time, when somebody agreed to donate, before they gave us anything, we would actually hand them the clipboard and say, well, go ahead and write your name and what it is that the amount you're going to give so we can have it for our records. Well, they would see these higher donations, and wouldn't you know it, their donation amounts went up. We started getting 5s and 10s, even a few 20s. So long story short, these methods of persuasion work, and they can be employed in day-to-day life. And the law, the way that they work, goes something like this. I'm negotiating a contract. I say, well, my client really wants both of those terms, but they're willing to give in on this one, and hopes that your client will be reasonable and give something back, right? That's what reciprocity looks like. I give, you give. Social pressure looks like that's absolutely not industry standard, right? That clause is so beyond what's acceptable in our industry that it's not going to fly. Something like that, some version of that. It tends to be really effective in pretty much every circumstances. People are very beholden to social pressure. Now, you know, those are fun games and those are super helpful. As to my practice, do I employ them? Not a whole lot, not really. The few things that I have found to be extremely useful in persuasion are, first, always understanding leverage. And this one is something that takes a lot of practice and time and thoughtfulness, but you have to understand how badly each party needs or wants the deal to go through. You have to take everything into consideration. How long the deal has been dragging on, what the individual players involved in the deal need out of it to make it feel like a win for them. What's motivating them? What's the risk if it doesn't go through, right? If you're talking about settling a case before it goes to litigation, well, the risk is pretty big. But if you're just talking about, you know, they're trying to decide who to hire for this PR contract that they're doing. Maybe the risk is less small because the second best person is probably close to as good as the first best person. So it's understanding all of these intricacies and understanding whether or not they understand all of those intricacies. What's their perception of their leverage? What's their actual leverage? And then putting that all together and coming up with a number that really feels fair and reflective of this respective leverage. Or you can take advantage of times in which, they perceive their leverage to be less than it is, which happens a lot. So really understanding each individual person involved, the companies involved, the risks if it doesn't go through, and spending some time being very thoughtful about that, because the chances are they are too. And, often when two litigators who have been in the game for a long time are negotiating around a settlement on a common case, it's pretty quick sometimes to get to that number because they both have a fairly good idea of the risk that comes with litigation and the likelihood that one party is going to win or prevail over the other, given the facts. Won't stop one of them from posturing and pretending to have a stronger case than they do. That often happens. But knowing where your case is half the battle. I have about a dozen stories about this. One of them, I had a client who was a model, and she had hired a photographer to just do headshots. Unbeknownst to her, he sold her headshots to a big company whose name you all know. And they put it on t-shirts, and they sold these t-shirts. And she didn't know it. And she gets a call one day from her friend, like, I'm in such and such store and I saw your t-shirt, congrats. And she said, what? I didn't sell my headshot to anybody. So long story short, this company had bought her photograph without permission, right? And so under the law, she's entitled to 100% of the profits that they made off of her image. So they're allowed to take out the costs, right? The cost of the t-shirts, but they have to give her the full value of the profit. Well, so we asked for their profit sheets associated with the product. And when we got them, buried in the fine print, they had it assessed as one of the costs, like a quarter of the rental space for this like massive store that sold thousands of goods. Like her one t-shirt took up a quarter of the real estate. So obviously, that wasn't an accurate assessment of what they were owed under the law. So when I did the math, an accurate assessment of what she was owed under the law was $30,000. And this was a company with a lot of resources and like definitely can handle $30,000 without blinking an eye. Probably not even running it up the flagpole. I happened to be co-counseling on this case with another attorney who had brought me in to negotiate. It was primarily his client. And they came back so we demanded, the $30,000, and they came back and offered something like $10,000, just ridiculously low. He said, okay, well, we should counter with, $25,000 or $24,000 or whatever, try to get this done. And I said, no, we have 100% of the leverage here, and they have zero, because it's a slam dunk case. No one's disputing liability. The amount of damages is readily ascertainable. They would be on the hook probably for attorney's fees, but definitely for prejudgment interest. Our risk is zero, and their risk is high because it would also look very bad on a PR front for them that they had, that they were doing this. And so he said, well, we have to counter with something. What do we counter with? And I said, this is that rare case where you don't counter with anything. You say simply, obviously we are too far apart. We are entitled to the full $30,000. It looks like we're going to have to litigate it, and I'm sorry we weren't able to come to a resolution. Period. Send. Within 48 hours, we had the full $30,000. And I say this not to say, oh, I'm such a great negotiator, but my skill in that negotiation was just purely based on being able to properly assess who had what leverage, who had what risk points. It's not usually that easy because there's seldom a time when one party has 100% of the leverage and the other party has none. But when it happens, you've got to use it, right? You got to take that leverage off for a spin because it is very rare. Okay, so that's rule number one is know the leverage. Number two, And this is there's going to be three of these, three of the tools that I use in my day-to-day practice to be really effective negotiator and persuader. The second one is to know more than everybody in the room. And I know that sounds like a high bar, and that it's not always going to be worth it to be the person that knows more than everybody else in the room. Sometimes it's going to be cost prohibitive to spend that much time, but if it's possible, know the facts better, know the law better. The person who establishes credibility early on tends to have the most persuasive capability. And this, I see this time and time and time again. It was true when I was arguing in court. It was true when I was teaching law school. It's true when I'm pitching a new client. If I'm the one who's the most knowledgeable and nobody can really even argue on my level of knowledge, it's really easy to persuade people, believe it or not. It really goes to credibility. And the third and the single most powerful method of persuasion is probably the one that takes the longest to develop, but it's story, the art of story. Data shows, and I do understand the irony of using data to show how unpersuasive data is, but the data shows that when people are firmly entrenched in a belief system and you provide them data which contradicts their belief system, most of the time it actually further entrenches them into whatever position that they're in. Whether it's a political issue or a position on a case, they tend to double down because cognitive dissonance is very uncomfortable. The most effective way to actually change people's minds on issues is through story. And this is true despite that, statisticians will tell you how unreliable anecdotal evidence is and why it's not really even considered evidence. Stories sell. Whoever creates the most compelling narrative and the narrative that makes sense, the narrative that's cohesive among all the facts, is probably going to prevail. Because at the end of the day, humans are hardwired to both remember stories better than facts and to be persuaded by stories better than facts. If you are in bet the house litigation, really critical litigation that you cannot afford to lose, and you are searching for legal counsel, above all other things, make sure you get someone who is an adept storyteller. You can have a brilliant lawyer, somebody who has great analytical skills, someone who has great research skills, someone who has been in that practice area for a very long time and understands it intimately. But if they're not a person who can look a jury in the eye and tell a story that has the jury already won over by the time opening is over, then they may not be the most persuasive person to add to your team.